Good morning, ladies and gentlemen. My name is Janet Rosenzweig. I have the privilege of being the Executive Director of APSAC, and I have the pleasure of welcoming you to the second day of what we know is turning out to be a wonderful experience. We hope you agree. As Dr. Corwin, our president, said yesterday, the state of APSAC is good, but it would be a lot better if you were to join. So I want to encourage you, while you're here today, to help our professional society, your professional society, grow, develop, and sustain, and continue to adding value to our profession so that you can add value to the communities and families that you serve back home. If you join today, we will offer you a 20% discount on membership. You can see our wonderful folks back at the registration table, and you'll be entitled to all of the benefits of APSAC membership, including our publications, discounts to our trainings and programs, and many wonderful other opportunities for networking. One of those opportunities, which we strongly encourage folks to take advantage of, is the development of state chapters. We currently have active chapters in 8 states. We've got 2 state chapter representatives now sitting on our board of directors, and we very strongly encourage you to consider joining the chapter in your state, and if there isn't one, let us help you start one. We provide startup grants, we provide technical assistance, we provide materials, camera-ready logos to build a website, all of the great stuff it needs to develop a state chapter. And if you have interest in developing a chapter in your state, we invite you to join us in the presidential suite, which is 4904, at noon today. It's a bring your own lunch. We can't quite afford to treat. But if you come on up and hang out, you'll have a beautiful view from the top of this building, and you'll get to meet our chapter representatives and see about getting a chapter going in your state. We really encourage you to do that. They do lots of good stuff. We also ask that whether you're a member or not, you stop and complete our member survey. That will help us understand how to better continue to serve you in the months and years to come. And for everyone who has filled out a survey, we will be pulling a drawing for a free membership. So that's an extra added attraction to help you consider giving us your information. I've also been asked to remind you to turn in your CEU packets if you've applied for CEUs. They're accepting those also at the registration table. And of course, our program evaluations are very, very important. We also want to ask, last night, for those of you who joined us, we had a lovely reception, which included a fabulous silent auction. And I just want to ask if our folks from the New Orleans CAC and the Audrey Hepburn Care Center, would you guys please stand up and let us thank you, because you really know how to throw a party. Thank you, thank you, thank you. Stacy LeBlanc, Hannah Gilbert, all of the staff and interns, they just have gone out of their way to make us feel as welcome as can be in New Orleans. They also had wonderful silent auction items. There's 5 people who won their auction item last night and didn't pick it up, so they're waiting for you at our registration desk, so please do that. And if one of you happens to forget, there's something I have an eye on to bring home to my mom, but we hope everybody else shows up there to go get that. Our call for papers for next year's colloquia, which will be held in Salt Lake City, will be available in about a week at our lovely new website, apsac.org. Please visit that site often. We've got great resources for you. We've got a searchable database of academic programs, so if you're looking for, to get a master's or a doctorate and you're looking for something with a specialty, we've got that all ready for you. So please be sure to visit our website and definitely look for the call for papers, because we want to see all of you and then some at our colloquia next year in beautiful Salt Lake City. So speaking of Utah, this is our segue. It is my pleasure to introduce my pleasure to introduce the president of our board, who also had the privilege last year of being the man that won our 50-50 drawing. And because he won our 50-50 drawing and, hint, hint, donated his winnings back, but that's optional.
We're We're not saying you have to do that.
No, I would like to bring Dr. Corwin up to the podium and ask him to pull this year's winner before we move to the next part of our opening program. And there's an envelope of money right here waiting for somebody.
Do we know how much money's in that envelope?
Yes.
You want to say it?
$271, enough to have a very nice dinner tonight.
And I pulled Carmen. I am so glad that you stayed. Thank you so much.
Yay, Carmen.
Come on up, please.
Seriously?
Carmen, all right. Carmen, without any arm twisting, Carmen has donated all of her winnings to APSAC. Way to go, Carmen. Hey, that was really legitimate, I promise you. Please do join APSAC if you're not. How many of you are not members of APSAC? Raise your hands if you're not already a member. Raise it high. Okay. Well, you should be, because APSAC can help you in your work, it can help support you, it can help provide you the information you need, and you don't want to miss the ride that we're going to be on over the next several years. It's looking very exciting, and this is going to be fun. I see some former board members smiling, but this you do not want to miss this. It's my pleasure to introduce a long-standing supporter, former board member of both APSAC and ATSA, Paul Stern, a 30-year, 35-year, 40-year child abuse prosecutor. He started very young up in Washington, and he's been steadfast in his support. Many years ago, like 20 years ago, 25, 30 years ago, he was asked he's an advocate, he's a prosecutor, he's a lawyer. He was asked to argue the side of why not to video record child interviews. And he argued it eloquently. And prosecutors from all over the country used his then published arguments against video recording and really slowed down the whole process for a couple of decades. He's now written his current real perspective, not a straw man argument, but what he really thinks. And that will be coming out, hopefully, in one of the APSAC publications within the next year or so. So I'm not going to tell you what he said. It's up to him. But, okay, thank you. Without further ado, Paul Stern.
Well, good morning. For those of you who are not APSAC members, he's going to strong-arm you. So just do it before David shows up and takes your credit card from you. It's going to happen. But you really should be. I would really encourage it. It's the best way for professional growth and a great group of people. One of the great group of people is Elizabeth Letourneau, who I'm just thrilled to be able to be here, frankly, to listen to her. I'm a retired now prosecutor who came down from Seattle simply to listen to Elizabeth, because I think what she's going to tell you is that important and that good. Elizabeth, let me tell you the details. She's a professor with tenure at the Department of Mental Health. She's the inaugural director of the Moore Center for the Prevention of Child Sexual Abuse at Johns Hopkins Bloomberg School of Public Health. She runs the place. For 30 years, she's been conducting research involving the development and rigorous evaluation of prevention and intervention programs aimed at addressing youth sexual violence and related youth risk behaviors. What she's focused on, what she's going to address for you, and what she's brilliant about, is taking the research and using it to impact public policy. That's her field. She, because why not, has done a TED Med Talk, coming fantastic thing at the TED Talks, on the prevention of child sexual abuse. She served as an expert witness for the Australian Royal Commission into institutional responses to child sexual abuse, worked with the World Health Organization, and helped develop the guidelines for responding to sexual abuse of children and adolescents. She's a member of the Maryland State Council on Child Abuse and Neglect. I was delighted to serve as a board member on ATSA while she was the president of ATSA, former ethics director, as I recall, of ATSA. She received the award for outstanding article on child maltreatment. By the way, APSAC folks, you get that when you join. She received the award for the outstanding article on child maltreatment in 2007 and the outstanding research article in 2008. Now here's the part about her that annoys me. It pleases me that she's been cited as an expert by multiple courts, Supreme Courts around the country. Because it's nice to have that courts, which I care about, relying on great quality research. The part that annoys me is whenever I open up a Time magazine, there's an article by her and an op-ed piece. It really annoyed me when I opened up Sports Illustrated, and there's an article, and they're talking about her. But what annoyed Elizabeth was she was in Sports Illustrated for her work and not for being an underwater polo player, which she is. She's also a great runner, a fabulous mom, a fantastic friend, and she's here because she is an absolute fierce and brilliant advocate for children. I am truly delighted. There is no one better to address the issues before you than Elizabeth Letourneau.
Thank you, Paul. And thank you, Janet, and all of APSAC for inviting me here to present today. I'm really delighted. The slides will be posted to the APSAC website where handouts are available by the end of today, just so you know. Bobby's childhood was tragic. He was raised by substance-abusing parents who divorced before he was born. He was subjected to harsh physical punishment and constant belittlement by his father, who retained custody. And he was sexually and physically assaulted by his mother's second husband. There were a few bright spots. Against all odds, Bobby was born at full term, met typical developmental milestones, and achieved good grades. Bobby's father maintained regular employment, and his second wife was kind to Bobby, although ineffective at parenting or protecting him due to her own mental health issues. Children, of course, require more than 1 out of 4 parent figures to be loving, or at least not abusive, to thrive. And so Bobby did not thrive. Having no good models for emotional regulation, he failed to learn to regulate his own emotions. Having too many models of verbal and physical aggression, he became verbally and physically aggressive. And having been sexually victimized, he learned to use sex as a weapon. At the age of 9, Bobby initiated inappropriate and harmful sexual behavior with a younger relative, a 5-year-old boy, towards whom Bobby's father demonstrated love and tenderness. It baffled Bobby watching his father, who had never shown anything but disdain for Bobby, behave so differently, so nicely with this younger boy. And it made Bobby want to hurt this boy, to punish him for usurping paternal affection that was by rights his. The younger boy was medically fragile, and his older siblings were punished severely when they were too rough with him. So instead of hitting the younger boy, Bobby sexually abused him, made him give Bobby oral sex, Bobby was 9. There is no way he could have understood the consequences of this behavior, apart from having some notion, based on his own victimization, that this would hurt the younger boy. Bobby kept this up for 3 years, and the younger boy stayed silent. Meanwhile, Bobby's behavior deteriorated at school and at home. After threatening to kill a classmate, Bobby picked up his first juvenile offense for disturbing schools and was placed on probation. He was 11 years old. And he began lashing out at his father. As a result of one particularly violent incident, Bobby was placed in a residential treatment facility to address his aggressive behavior. While at this facility, an older boy tried to anally rape Bobby, and when Bobby went home on a weekend pass, he anally raped his younger relative. After a few of these exponentially more horrific episodes, the younger boy finally broke his silence and told Bobby's stepmother about the abuse. When confronted by his stepmother, Bobby confessed immediately. He wrote her a letter saying that he knew his actions were wrong and that he was glad it was over, that he hoped his younger relative would be okay. But no one in this story is okay. Not now, and maybe not ever. Bobby's stepmother knew Bobby needed help, but she didn't know where to find it. So she called the police, and she showed them Bobby's letter. The prosecutor assigned to that case used the letter, that confession, to convict Bobby of the harshest possible charge, criminal sexual conduct with a minor in the first degree. And the judge sentenced Bobby to prison for the longest possible term, 5 years. He was 13 years old when he arrived and 18 years old when his prison sentence ended. And in the intervening years, Bobby reinvented himself. Away from his abusive father, Bobby learned something about self-control. His brain continued to mature as young brains will, and he developed the capacities for empathy, understanding, delay of gratification. The prison social worker attested to his improved behavior. A review of records showed declines in disciplinary infractions as each year progressed, and specialized risk assessment measures documented that Bobby was attracted to young women, not to little boys. Prison is no place to raise a child, but prison is where Bobby found himself, and ultimately he made the best of it. Completing sex offender therapy, earning his GED, and picking up some vocational skills. When it was time for release, Bobby had prepared himself as best he could for the outside world. But this was not to be the end, or depending on your point of view, the beginning, for Bobby. He was not released from incarceration after spending 5 formative years in prison. The state where Bobby resided is one of 20 states that operate sex offender civil commitment facilities. These facilities are designed to indefinitely hold and treat adult sex offenders who are deemed too dangerous to release back into the community at the end of their prison terms. Sex offender civil commitment was designed for men like Earl Schreiner. While incarcerated for earlier sexual assaults against children in the 1980s, Mr. Schreiner promised that he would continue abusing children if he was ever released from prison. He was released, and he made good on that promise with the sexual mutilation of a young boy whom he left for dead in the woods. Sex offender civil commitment was never intended for minors, for people who commit their sexual offenses before the age of 18, certainly not for people who committed their offenses at the ages of 9, 10, 11, or 12. And yet Bobby's state decided, against all credible evidence, that he presented a threat similar to that of Mr. Schreiner, and they fought to put him away in a high-security sex offender civil commitment facility, a facility whose own director went on record to say that Bobby did not belong there, that Bobby was inappropriate for that facility and would be endangered by the more truly dangerous men already housed there. These pleas fell on deaf ears, and Bobby was committed. That director supported Bobby's annual efforts to secure release, Each year, Bobby's lawyers would request his release. Each year, the state would deny release, and a jury trial would ensue. Jurists never deigned to release Bobby from civil commitment. Finally, Bobby's lawyers won his release through a state Supreme Court challenge. He was 22 years old. And that is the end of what I know about Bobby, except that no matter where he lives, whether in the state that incarcerated him or any other state, he will be subjected to sex offender registration and public notification for the rest of his life. Every 3 months, he will have to present himself to a sheriff's office or state law enforcement facility to have his picture taken and posted on a public sex offender registry, along with his home address, his work address, many other pieces of information. There are hundreds of scientific publications demonstrating that incarcerating children does little to improve community safety, and indeed can increase the risk that a child will commit new offenses. There are dozens of scientific publications, many of them my own, demonstrating that subjecting children to registration and notification does nothing to improve community safety. Instead, juvenile registration is linked to increased risk for harm, a topic to which I'll return shortly. And maybe some of you think that's fine. Maybe you believe that anyone who sexually abuses a child deserves a decade or more of confinement, a lifetime of public shaming on the registry. Maybe you don't care whether these interventions actually improve community safety, so long as they punish sex offenders. But does any of this make sense for a child? For any child, but especially a child whose behaviors were so clearly tied to his own victimization? Does a victim become a perpetrator, and that's that, no matter what his age or his experience? Maybe you think it does make sense. That regardless of age or experience, these people, sex offenders, get what they deserve. In that case, what about the victim? Nothing that happened to Bobby helped his victim. Nothing about a state's decision to wait until harm has occurred before intervening helps any victim. Based on public records, Bobby's year of residential treatment cost approximately $90,000. His 5 years in youth prison cost $250,000, and his 5 years in sex offender civil commitment cost $315,000. Then there are the costs associated with the initial prosecution for the school offense, prosecution for his sexual offenses, the 4 jury trials, the state Supreme Court trial, and lifetime sex offender registration and public notification. Collectively and very conservatively, this state invested more than $700,000 in Bobby. And none of that money made one bit of difference to Bobby's victim. How much money do you suppose that state invested in prevention efforts? In Bobby's records, to which I had access as an expert witness for one of his trials, I found little evidence that he or his parents were ever provided with effective prevention or treatment programming. Several programs worked to prevent at-risk parents like Bobby's from abusing or neglecting their children. You know this. Programs such as Nurse-Family Partnership and Safe Start. Likewise, several early intervention programs effectively address a child's disruptive behaviors, such as the Incredible Years and parent-child interaction therapy. And there are well-validated treatment programs that effectively address a teenager's serious delinquent behaviors, including harmful sexual behaviors, such as multisystemic therapy for problem sexual behavior. Had the state elected to provide these prevention and early intervention programs to Bobby and his parents, the total bill would have amounted to less than $25,000. That's 28 times less than the state ultimately paid out. And Bobby might never have sexually assaulted his younger relative, or the abuse might have been discovered and addressed before it progressed to rape. Designating massive resources after sexual abuse has occurred and almost no resources to prevent abuse is a choice. It's a choice that harms children, and it's a choice that harms all of us. So why do we do this? Why do we put nearly all our money, time, and effort into punishment? I believe that we focus so much energy on after-the-fact responses because people don't really believe that child sexual abuse can be prevented. Instead, we believe that people who sexually abuse children are monsters, that they are the ultimate other, and the best we can do is to keep them out or lock them up no matter what the cost. We believe that people who commit sex crimes are on an irreversible trajectory toward more offending and greater harm. We believe they are all Earl Shriners. This is simply not true. It may surprise you to learn that about half of sexual offenses committed against prepubescent children are committed by other children, children under the age of 18 and usually under the age of 15. Hundreds of research studies, including my own and that of the work of Michael Caldwell, who based his findings on tens of thousands of cases, finds that 97% of children, 97%, who are adjudicated of a first sex crime are never adjudicated of a second sex crime. 97% do not go on to reoffend sexually. Clearly, these children are not on an irreversible trajectory towards more or worse offending. Moreover, the fact that so few of them reoffend with a new sex crime suggests that we probably could have prevented the first one. We know that children act out sexually for any number of reasons, including ignorance, impulsivity, inadequate adult supervision, including exposure to harmful role models, to developmentally inappropriate sexual stimuli, to sexual and physical assault. Developing, evaluating, and disseminating effective prevention programs that will prevent harm from occurring in the first place, should be a national priority on par with prosecuting and punishing children after they've already engaged in harmful behavior. To build a truly comprehensive approach to child sexual abuse, an approach that includes effective prevention efforts, requires resources. Elected officials tell me that they agree it would be better to prevent child sexual abuse than to react to it, that no child should have to experience sexual abuse. They understand that prevention is probably more cost-effective than after-the-fact intervention, but they just don't have the money. Yet they have $700,000 to invest in Bobby. My colleagues and I recently published an economic evaluation of child sexual abuse. We estimated the annual economic burden of child sexual abuse to the United States is more than $9 billion. We have the money. We have the money to focus on and fund prevention efforts. We just choose to put it elsewhere. We choose to put it into policies like juvenile sex offender registration and public notification. So let's review the research on the effects of juvenile registration and notification policies, research that my colleagues and I began in 2003 and continue today with the help of a lot of funders. So as not to bury the lead, I'll say up front, there's no evidence that registering children reduces recidivism or prevents first-time sex crimes. There is evidence that registration influences juvenile justice procedures, and there is evidence that these policies hurt children. 3 studies have been published that specifically look at the impact of juvenile registration policies on sexual recidivism. My colleagues and I conducted the first 2 of these, one that included evaluating matched pairs of children who were registered and not registered but had been adjudicated for the same crimes. Recidivism was unaffected by registration status, and in fact, recidivism was very low, less than 2%. In a second study, also in South Carolina. We looked at every single boy that had an adjudication for a sex crime and followed him for about 9 years. Again, we found a very low recidivism rate, and again, we found that recidivism was unaffected by registration status. Michael Caldwell and his colleague used data from Wisconsin to evaluate the effect of registration on recidivism, and again found there was no such effect. Arguably, the main point of registering children is to reduce sexual recidivism. No research finds that it does so. 2 other studies have specifically evaluated tiering. In the Adam Walsh Act of 2006, which is the first act to establish a federal requirement to subject children to registration, it also includes recommendations for tiering, such that children in Tier 3 are considered high risk and must register for life. Children in Tier 2 are considered medium risk and register for 25 years, and children in Tier 1 are considered low risk and register for 15 years. Ashley Battistini and her colleagues conducted an evaluation to see if tiering had anything to do with recidivism, and it does not. Children in the higher risk tiers were no more likely to reoffend sexually than children in the lower risk tiers. And Michael Caldwell, in another study, found the same. Children in Tier 3 were no more likely to reoffend sexually than children in lower tiers. The only other way that juvenile registration could affect and improve community safety, if it doesn't reduce recidivism, is to prevent first-time sex crimes. This is the argument that's used in support of capital punishment, that if you make the punishment so severe, it will cause people to think twice about engaging in the behavior in the first place. So does registration reduce the likelihood that a child will engage in a sexual offense in the first place? 3 studies have been published looking at this general deterrent effect, all by me and my colleagues. In one study, we had data on first sex crime reports, so somebody calling the police and reporting a sexual offense committed by a juvenile. We had data from 4 states, tens of thousands of cases, and we found no relationship between the policy being implemented and the rate of reports. We used data from South Carolina in another study using every single juvenile sex crime charge over a 15-year period of time, and again found that the likelihood of a juvenile being charged with a sex offense was unaffected by policy implementation. We recently extended these findings in a paper that was accepted yesterday to Maryland and Oregon, and again we find no policy effect on first-time sex crimes. Juvenile registration does not improve community safety because it does not influence juvenile offending. So then what does juvenile registration do? I got into studying juvenile registration because of something that was happening in another study. I was running a randomized controlled trial, a large clinical evaluation project in Cook County, Illinois, that looked at the treatment effectiveness of multisystemic therapy for kids who had been adjudicated of sex crimes. And we picked Cook County, which includes Chicago, because annually they adjudicated about 400 kids for sex offenses. And when you're running a randomized controlled trial, you want a large group of potential participants to recruit. So we went to Cook County and we couldn't recruit kids. We were having a really hard time finding kids who had sexually offended. So I reached out to the state's attorney's office to see what was going on. And it turned out that in Illinois, they had passed a sex offender registration policy that accidentally included kids adjudicated as minors. And so instead of prosecuting these kids for sex offenses, they were hiding them under physical assault offenses. And I wondered if maybe that was happening in South Carolina, which had a much more draconian registration process for children. And so we looked at what happened to juvenile sex crime case processing from start to finish in South Carolina to see if policy implementation had an effect. And we found 2 effects. The first thing we found is that after 1995, when South Carolina initiated its initial registration, which called for lifetime juvenile registration, there was an large decrease in the likelihood of prosecutors moving forward on these cases. They dropped them and they dismissed them outright. We did not see anything like that for assault cases or for robbery cases, only for juvenile sex crime cases. The second effect that we found was on plea bargains. We looked at plea bargains for sexual assault cases, physical assault cases, and robbery cases. And we looked at 3 time periods. Before registration was enacted, 1990 to 1994, after initial registration was enacted, and then from 95 to 98, and then when online registration was enacted. And as you can see, there are large increases in plea bargains for the sex offense cases, but not for the other types of violent offending. There's a 124% increase in pleading from before registration to after registration was initially enacted, and another 50% increase in pleading after online registration came into effect. And these pleas were not from higher severity sex crimes to lower severity. They're from sex offenses to physical assault offenses. These are plea bargains out of type. You don't see plea bargains out of type for physical assault. You see kids go from aggravated to simple. And you don't see plea bargains out of type for robbery. They go from robbery to theft. But you see these in sex crime cases. Registration and notification is supposed to increase information that people have about those who commit sex offenses. My friend Paul Stern notes that this means these effects, the dropping and dismissing of cases, the pleading of cases from sex to non-sex charges, these findings mean that we learn less about these children who are either not prosecuted or they're prosecuted for non-sexual offenses. I'll also say that anecdotally, people told me when kids come in with a sex offense but then are adjudicated for a non-sex offense, they don't get sex offense therapy, right? They get some other kind of therapy. From the beginning, there was concern that labeling children as registered sex offenders would cause harm. Nicole Pittman worked for Human Rights Watch and published a report called Raised on the Registry, where she documents information from more than 500 interviews that she conducted with families affected by juvenile registration. And the children and parents in those families report harrowing experiences. One family had 2 boys on the registry who were both there because they are engaging in behavior with each other and with their friends. And someone went by and shot out the windows of their house. She talked with parents whose children had committed suicide, parents whose children had attempted suicide. But there wasn't a lot of more empirical research on the effects of registration on children. And so my colleagues and I have surveyed samples of 4 populations, practitioners, people who provide direct treatment services to kids who have engaged in harmful or illegal sexual behavior, the children themselves, their parents, and young adults in treatment for sexual offending between the ages of 18 and 21. The results that we've published pertain to the practitioner and the child surveys, and those are the results that I'll present today. For our practitioner survey, we were able to recruit 265 practitioners across the entire United States. We have representation from almost every state. You can see some other practitioner demographics there and their client profile. So they all treated at least some people under the age of 18, children under the age of 18. About half of them treated children under the age of 16. Of course, most of their child clients are boys. Most of them have formal adjudications because that's how you get into treatment. And then 30% had a non-sexual offense, which is a pretty standard finding. And we asked these practitioners to respond to questions, and the questions were worded like this. Compared to a non-registered child, a registered child, and then we present the rest of the sentence stem, and they indicated disagree, don't agree, disagree, neutral, or agree. So we had items in 5 domains: mental health, harassment and unfair treatment, school problems, living instability, which of course is very damaging to children, school-age children, and risk of reoffending. And what we found was really astonishing. There was, in some items, almost universal agreement that registration and notification harm children. So compared to non-registered children, registered children are more afraid for their own safety. 89% of our sample agreed with that statement. Compared to non-registered children, registered children have less hope for the future. 89% agreed. They agreed that that registered children were subjected to harassment, not only by peers, but by adults. That registered children had more school problems. That registered children had more living instability. They didn't believe that registration increased the likelihood of offending either sexually or non-sexually. We re-examined our findings, trying to take into consideration practitioner demographics and also some of those client characteristics that you saw in the earlier slide. And none of that changed the outcomes. None of that influenced practitioner responses. So these responses are very robust across all types of practitioners. People that make a living working with kids who have caused sexual harm find that registration and notification hurts them. And then we surveyed children. So we were able to recruit 256 kids, ages 12 to 17, across 18 states with very different registration requirements for children. Of course, most of them were boys, just 5 were girls, and you see some other demographics. 29% of our sample was subjected to some form of registration and/or notification requirements. Registered children were on average a little bit older. They were more likely to have a formal adjudication, of course, because that's how you get registered, is when you've been adjudicated. And there were a few other differences, and so we controlled for all of those differences in our findings. Compared to non-registered children, registered children reported more mental health problems across all of our mental health measures. They reported more peer problems and peer relationship problems, and they reported a lower sense of safety. They were nearly 4 times as likely to report having attempted suicide in the past 30 days. They were nearly twice as likely to report having been sexually assaulted with a contact sexual assault in the past year, and they were 5 times more likely than non-registered children to report having been approached by an adult for sex in the past year. 4 times more likely to attempt suicide, twice as likely to sustain a sexual victimization, and 5 times as likely to be approached by an adult for sex. Why might registered children attempt suicide at higher rates than non-registered children? I think it's because labeling a child as a registered sex offender communicates constantly and in a variety of ways that he or she is dangerous, feared, worthless, and has no real future. This is the same reason I believe that adults prey upon registered children at higher rates than non-registered children. Registration is designed to label some children as the ultimate other, to equate them with the Earl Shriners of this world. So to summarize, juvenile registration policies do not improve community safety by reducing sexual offending. They have unintended consequences on juvenile sex crime processing. They confer substantial risk of harm to children, including the most serious types of harm, and including the type of harm that they are designed to prevent. Registration was supposed to prevent the sexual abuse of children, and it's associated with an increased risk of sexual abuse in children. Our Street Institute is a libertarian think tank group in DC, and they published a cost-effectiveness evaluation, a cost-benefit evaluation of juvenile registration. The cost was in the billions, but they specifically pulled out the costs to local, state, and federal government and estimate that we, taxpayers, spend between $10 and $100 million annually to administer juvenile registration policies. That's a lot of money to spend on a failed policy. In spite of this evidence, I do still hear arguments in favor of juvenile registration, and they typically boil down to two main points. The first is that we don't want to take away a tool from prosecutors. But do prosecutors need or even want a tool that's associated with increased risk of suicide or sexual assault of children? Prosecutors seem to think not. The Association of Prosecuting Attorneys published a paper by Paul detailing the many harms of registration and arguing for a more informed approach. This paper is available at the APSAC website. The second argument is that we have to look out for the interests of children, of victims. And indeed we do. Each of us is charged with looking out for the best interests of children. My argument is that this concern rightly pertains to all children, including children who have made mistakes, and including children who have harmed others. Moreover, victims are not served by failed policy. Many individuals and organizations have concluded that juvenile registration causes more harm than good. These include Patty Wetterling, whose efforts launched modern registration practices, and Detective Bob Schilling, who led Interpol's Crimes Against Children Division. These include liberal organizations like the Open Society Foundation and conservative organizations like R Street Institute and Right on Crime. These include politicians all across the United States from Delaware to Oregon, and even in South Carolina and Texas. We all want to prevent child sexual abuse, every one of us. Juvenile registration was one attempt to do so. It's time to recognize that this particular effort does not work. It's time to redirect those resources to effective efforts so that children like Bobby, children like my own boys, receive what they need before harm occurs and, when necessary, after harm occurs. It is time to end juvenile registration. Thank you.
Well, the plenaries at this meeting have been extraordinary. How many people agree with that? Absolutely, absolutely. I have a workshop change announcement. The workshop that was entitled Opioid Abuse, a Significant and Growing Crisis for CPS has been canceled, and in its stead is a new workshop entitled Current Critical Policy Issues in Child Maltreatment. It'll include presentations about APSAC's current Center for Child Policy initiatives, including the treatment of juveniles with sexual behavior problems, mandatory reporting laws, recent APSAC amicus briefs, and emerging issues related to immigrant children. The speakers will be Elizabeth Letourneau, thank you for double duty, Paul Stern, Frank Vandervoort, Kelly Hughes, and Pamela Miller. And it will be in the south down room on the 4th floor. That's over that way. You just go down one floor and it's at the very end of the building. South down on the 4th floor. Thank you very much. Do we have more? I think that's the end of the plenary session, and now oh, yes, thank you. I have it written down here, but Janet reminded me, and this is from the heart. You know, one of the things about having such a great time in New Orleans is that it gets harder and harder day by day the next morning. But Jim and Jane Campbell have been incredible, you know, at taking care of the needs of all of us involved in putting on the colloquium. Let's have a big round of applause. Are you in the room, Jim and Jane? I can't see. Jim's in the back. Jane's at the registration desk. Thank you so much. Last night we had a president's reception up in the presidential suite, which the hotel gives to APSAC. Just want to make that clear. And but Jim and Jane, as usual, taking care with the rest of the volunteers and troops, and I did nothing but talk to people. And boy, is that nice. I thought I was going to have to be working hard and getting food, bringing it in, and just, you know, they're just incredible. So thank you very much. I wish that we could have invited all of you. It's just that that room is a lot smaller than this room, and it wasn't possible. Thank you.